Hi everybody, I'm Gwendolyn Sterk of Sterk Family Law, and I'm here with Terry Fogarty of our office, who does estate planning as well as guardianship work, and we're going to talk about the steps of guardianship proceedings in Illinois.
Excellent.
So Terry, you get into a situation, and we have a lot of clients coming in where they're seeing signs of dementia or they're seeing an Alzheimer's patient, and maybe that individual never created their estate plan. What do you say to your family in that situation?
Well, for a lot of folks, a guardianship might be the best option in those circumstances, because at that point, if you don't have an estate plan prepared and the mental capacity is really starting to slip there, and those folks really aren't able to comprehend what they're doing, you really don't want to move forward in drafting some form of estate plan, because they probably didn't have the capacity to do so.
Sure, so you want to double protect and make sure that you're getting the appropriate guardianship to make the decisions, correct?
Correct.
Now, I'm sure that there are several steps that need to be taken in order to go through and present your case to the court. What is really step one?
So really step one is getting a physician's report.
Okay.
And a lot of times you'll already have this, and that's probably how you came to the realization that you might need a guardianship. Your family physician or the alleged disabled person's physician may be telling you, their mental capacity is slipping. They have something like dementia or Alzheimer's developing,
okay,
and they may not be able to care for themselves, or they may be putting themselves in danger.
Got it. So now, how recent does that physician's report have to be able to go into court and say, I believe this individual needs a guardianship?
Well, it has to be within the last 3 months.
Okay.
It's very important that it be a fresh physician's report, because the alleged disabled person's capacity can change. There are times when the capacity can get better, but
Sure.
there are other times when it can get worse. So by law, it needs to be within the last 3 months.
Okay, so I've got a little bit of an odd issue here. So I'm thinking, all right, Grandpa sees a doctor, but that doctor's not going to release a report because he says that Grandpa's not capable of consenting under his HIPAA rights to give the report. What can I do if I want to step up to the plate and be guardian of Grandpa?
Well, your second step, and one that a lot of people might consider depending on the timing of everything and how crucial it is to become guardian, is to file the petition for guardianship.
Okay.
And as a secondary part of that, if you're unable to get a physician's report from the physician for any reason, you can always ask a judge to order that physician to grant that report, or at least order the medical records to be available.
Very good.
Or order a physician's examination to be done.
Got it. So now, is the court going to just take my word and the word of the physician, or is the court going to take another step to protect the potential ward's rights?
So in general, a court, once you file for a guardianship of a disabled person, they will appoint what's called a guardian ad litem.
And it's different from a guardian, right?
It is different from a guardian.
Okay.
The guardian ad litem is actually another attorney.
Okay.
And that attorney is appointed to represent the interests of the alleged disabled person. Okay. In other words, they don't work for the person who wants to be guardian. They're there actually to make sure that a guardianship is the right step to take for that alleged disabled person.
So really, they're the eyes and ears of the court to be able to report back to the court whether or not it's necessary in the first instance. Is that correct?
That's correct.
Now, if a potential ward or the person who's in need of the guardianship says, heck no, I'm not going to have a guardian, I want to make my own decisions, they think I've got dementia but I really don't, do they have certain rights as well?
They do. They have a right to a hearing. They have a right to a jury trial. They have
6 persons, right?
6-person jury
Yes.
trial. So they do have a lot of rights. Obviously, the court doesn't want to take somebody's individual rights and decision making against them. And the entire guardianship process is geared towards maximizing their individuality and maximizing what they can and can't do, or maximizing what they can do. I apologize.
For sure. So, in that instance, the potential ward could get their own attorney or the attorney for the ward, correct?
Yes.
So in addition, so you could have an attorney representing the potential guardian. You're then going to have a guardian ad litem who's going to be an attorney looking out for the eyes and ears of the court to report to the court whether they believe a guardianship's appropriate, right? Mm-hmm. And then you're lastly going to have an attorney for the potential ward who's going to be able to argue on behalf of that particular ward.
It's definitely possible. It's definitely possible that can happen. The typical is to just have the attorney for the petitioner, the person who's
Sure.
attempting to be guardian, and then the guardian ad litem on the other side,
Right.
advocating for the ward.
But if the ward does take that position, the ward has rights as well, is what
Definitely.
we're trying to.
Yeah.
And then ultimately it'll go to trial, and then the jury of 6 persons will make the decision, correct?
Correct, if they choose that option, yes.
Got
Yes.
it.
And it's important to note, too, that the person who is a judge disabled, the ward, always has the right to come back into court and claim that they are now competent and no longer need a guardianship.
Right.
So it just goes back to what I said before about the fact that the courts really don't want to take somebody's individual rights and decision-making away from them if they don't, if
they don't have to.
for their protection.
On the flip side, if you're in that situation and you have a family member who has dementia, suffering from Alzheimer's, you might want to call us to explore what your options are and available remedies to address the situation at hand with your family. Is that correct?
That's correct, and definitely you want to be proactive in it because there's really nothing worse than waiting to the last minute. When it really becomes an emergency,
Sure.
And not having taken the steps that you could have taken to avoid that emergency.
And just so that we're clear, if you're asking in the case of Grandpa, it could be of the estate, it could be of the person, or it could be of both, as we talked about in other podcasts. Is that correct?
Correct.
Got
Yeah, it all depends on their actual physical abilities and their mental wherewithal.
Got it. Well, if you're listening today and find yourself in that situation, don't sit home paralyzed. Call us. Terry can give you certain advice. We can give you direction, remedies that might be available, and what might be in the best interest of your individual family situation. So thanks for your time, Terry.
Thank you, Gwen.